This is Bob Orr. As governor, I want to enlist every law enforcement officer in a major effort to reduce drunk driving on the state's roads and streets and highways. As much as anyone, you as a law enforcement officer know the carnage that is created by drunk driving. But let me give you some statistics that bring it home. You remember that airplane that landed on the bridge in Washington a couple of years ago? 73 people lost their lives, and film that we won't ever forget. Well, 73 people lose their lives every day of every year. 23 minutes between deaths on the highways, 25,000 people a year. All that on a national basis. What are we doing here in Indiana? It's estimated that there is a great loss of dollars, but it's what is the cost of a human life? That's what's bad. We're doing some things in the legislature and in this administration to try to provide for easier law enforcement, to close some of the loopholes. But we know that the cost of human life can be reduced only by stronger law enforcement, and that's where we must count on you. We know that until we can bring every last drunken driver off the road, that we'll not have success in this major effort. Enforcement is the key, and I ask your help in seeing that in the days and months ahead we accomplish the objective. Thank you.
There have been a number of changes in Indiana state laws governing drunk drivers and habitual traffic offenders. They all took effect September 1st of 1983. The 1983 General Assembly created a new criminal offense, a Class C misdemeanor, which is referred to by attorneys as the per se law. It means it is per se illegal to operate a motor vehicle with a .10 blood alcohol content. A driving while intoxicated offense remains on the books. The bill also provides for an automatic suspension, usually within 10 days, of the driver's license when a police officer swears out an affidavit to the Bureau of Motor Vehicles declaring that there was probable cause to suspect a driver of driving while under the influence of either alcohol or drugs with a .10 blood alcohol content. Now, this suspension may go into effect even before a criminal case is closed. Anyone arrested on probable cause who fails or refuses a test must be suspended for at least 30 days before a probationary or restricted license can take effect. Second and subsequent offenders may not be given a probationary license. The mandatory 5-day jail term for second or subsequent offenders is retained, but 10 days of community service is a new alternative. The implied consent statute has been completely rewritten. More than one chemical test is authorized, and if a person refuses to take a test, that refusal can be used as evidence in the drunk driving case. Doctors and hospital personnel who take a blood or urine sample from a suspect at the request of a police officer are immune from civil liability for taking the sample and for turning the samples over to a police officer. The new legislation also requires a mandatory 60-day jail term for persons caught driving while suspended due to a drunk driving conviction. These people can no longer drive away from the courthouse after a suspension with impunity. In House Bill 1162, a bill related to the drunk driving reform, the legislature transferred misdemeanor drunk driving cases of juveniles 16 or older to adult court. However, the juvenile court retains jurisdiction over felony drunk driving cases committed by all juveniles. A third bill, Senate Bill 169, effective September 1st, 1983, provides for an automatic Bureau of Motor Vehicle suspension of driving privileges for 10 years, that for people who meet the habitual traffic offender criteria. There are currently some 14,000 to 16,000 drivers who meet or exceed this criteria and still have their licenses. Now, this is just a brief overview of new laws. Let's examine the details and how they affect law enforcement officers. The revised statute no longer contains a list of factors to consider for probable cause. The old statute listed erratic or unusual behavior, watery or bloodshot eyes, a flushed face, contracted pupils, condition of clothing, ability to talk, finger dexterity, steadiness, the odor of alcohol, alcohol containers, etc., etc. Now, all of these factors are still relevant in deciding whether there is probable cause to believe the driver is intoxicated, but they are simply not listed on the new statute. Instead, the officer can rely on all the information he acquires in deciding whether the driver should be offered a chemical test. The roadside test can be one piece of information the officer uses to determine whether he has probable cause to offer the driver a certified chemical test. And since the new statute authorizes more than one test, the old argument that taking the preliminary roadside test satisfies the implied consent requirement is no longer valid. In fact, it never was. If the motorist fails the roadside test, the officer has an additional factor to put in his probable cause affidavit. If the officer determines that there is probable cause to believe the driver is operating his vehicle with a 0.10% blood alcohol content or higher, or is operating while intoxicated, the driver must be given the opportunity to submit to a certified breath test, a blood test, or a urine test. The motorist has no right to choose which test. Normally, the breathalyzer test is offered.
In the state of Indiana, prima facie evidence for intoxication is a blood alcohol content level of 0.10% or above. Okay? Now, due to the moderate odor of an alcoholic beverage on your person and on your breath, and your lack of field coordination, I have probable cause to believe that you may have exceeded this prima facie level. Okay? Now, in the state of Indiana, since I have this probable cause, I must offer you a chemical certified test for intoxication. In this case, it'll be the breathalyzer examination. If you refuse to submit to the breathalyzer examination in Indiana, your driving privileges will be suspended for 1 year. Do you understand that?
I do.
Okay, Mr. Doe, do you want to take the breathalyzer examination?
Yes, I'll take it.
Okay, if you'll step around to this side of the car, please, and place your hands on the fender.
The new drunk driving law no longer states that a person may not be arrested until he is given the opportunity to submit to a chemical test. Now the driver may be arrested when the officer has probable cause to believe he has violated either the per se law or the DWI statute. Now this clears up the issue of whether the driver may be handcuffed while being transported to a test site. The driver may now be arrested before the test is taken and transported to the test site in handcuffs. The law does not require arrest before the test, but realistically, where the officer has probable cause, the driver is generally not free to walk away from the encounter. And if he's not free to leave, he's under arrest. Where a driver is arrested for DWI or the per se law, the officer shall take his license and issue him a receipt for it. That receipt is valid until the BMV suspends the license. Now, the new statute retains the requirement that the officer shall arrest if the test results show a 0.10% blood alcohol or higher, and drops the old provision stating the officer shall not arrest the driver if the test results are 0.05% or below. Thus, an obviously intoxicated person may still be arrested even if the alcohol test is 0.05% or below. In such a case, a urine test or a blood test is permitted to detect the presence of other drugs causing the intoxication. If the motorist wants a blood test and the officer has access to medical personnel authorized to draw blood, then it's a good idea to offer the blood test. Results from these tests are virtually impossible to contest in court. Immunity for physicians and hospitals for taking blood samples has been broadened by the new law. Physicians and hospital personnel are more willing to help law enforcement since they are now immune from civil liability for battery. You see, technically speaking, sticking the needle into someone is battery under the tort law.
Step out of the truck, please. Step out of the truck and to the rear. switch off, step out of the truck and to the rear of the vehicle. What's the matter? Right, just step right back there to the rear. Right around back to the back. Right back to the spot. Mr. Rowe, put your cigarette out, would you please?
Oh, I'm not done with it yet.
Just put it out. I need to talk to you for just a moment. Put it out, please. Mr. Rowe, I have a small handheld alcohol testing device. You simply blow into it. It's just a small handheld box to give me some indication of what your blood alcohol level might be. You have the right to refuse to submit to that test, but I'd like for you to take it to give me some indication of your blood alcohol level.
I don't have to take it. I'm not going to take it. I don't want to take it.
You're not required to take it. Have you ever? That's fine. That's fine. Have you ever submitted to a field sobriety test?
I don't drink.
If you would, I'd like for you also to submit to a field sobriety test. Very simple. Stand, face me, put your feet squarely together.
If a driver refuses a roadside test, that information should be included in the probable cause affidavit. The handheld breath testing instruments are not certified chemical tests. If the motorist refuses the portable test, he must still be offered the opportunity to submit to a certified breathalyzer test or a blood or urine test. The driver must be warned of the consequences of refusing to submit to a chemical test. He must be informed that his refusal will result in the suspension of his driving privileges for a period of 1 year.
All right, straighten your arm back out again. Now with your right. Okay, that's fine. That's fine. You put your arms back down to your side now. If you would, bend over and touch the tips of your toes. Try to keep your knees straight. Okay, that's fine. That's fine. Just stand up there. I have probable cause to believe that you've been operating a motor vehicle under the influence of alcohol. Based on that probable cause, before I can arrest you, you have the right to submit to a chemical test by a qualified operator to indicate your present blood alcohol level. If you refuse to take that test, which you have the right to refuse, it's a mandatory suspension of your driving privileges for a period of 1 year. Do you understand that?
I don't want to take anything.
Do you understand what I've told you?
I don't want to take any of that stuff. Before I do anything, I want to talk to my lawyer. I'm not going to take any of that stuff.
If you refuse to take the test, you'll be arrested immediately.
I want to talk to my lawyer before I do anything else.
You do not have the right to talk to your lawyer before submitting to the test. Now, if you refuse...
I got to talk to my lawyer before I do anything. I got to be able to talk to my lawyer. I'm just going to go to my lawyer.
You're under arrest. You're under arrest. Put your hand...
I don't want to talk to my lawyer.
Keep him up there.
Many times a driver asks to call his lawyer before he submits to a chemical test. Recent Indiana case law has determined that when this occurs, the officer must inform the driver that he has no right to call or consult a lawyer before submitting to a chemical test. The officer must also inform him that if he insists on consulting a lawyer before taking a test, the law considers that a refusal, which, as we know, results in the loss of driving privileges for 1 year. Now, if the driver has definitely refused to submit to a chemical test, he may still be arrested for DWI and transported to the jail. The officer must take his driver's license if he has one and give him a receipt for it. Again, the receipt is valid only until the Bureau of Motor Vehicles suspends his license. A refusal situation is one of the more difficult arrest situations to handle. The driver is frequently belligerent and threatening. At the same time, the officer must remember to warn the driver of the consequences of a refusal. He will have to swear in the probable cause affidavit that the warning was given, and under the new mandatory 1-year suspension, he will frequently have to testify to that fact in court. Good field notes will come in handy later in all refusal cases. Once a driver has been transported to jail following a refusal or failure of the test, the officer must fill out a probable cause affidavit with the assistance of the prosecutor. When the officer has delivered his affidavit and the driver's license to the prosecutor's office will determine initially whether the affidavit sets forth sufficient facts to show probable cause that the driver violated 911-2 and is in conformity with the statute. The probable cause affidavit must contain 3 main points. First, it must include the grounds for the officer's belief that there was probable cause that the arrested person was operating a vehicle in violation of Indiana Code 911-2. Secondly, the affidavit must state that the person was arrested for such a violation. And third, it must state that the person refused to submit to a chemical test when offered, or submitted to a test that resulted in prima facie evidence that the person was intoxicated. These facts must be sworn to by the officer.
The affidavit looks good. Clearly shows probable cause that Richard Rowe was operating his vehicle while intoxicated, and that he refused a breathalyzer test. Did you advise him of his duty to take the test and the consequences of his refusing to do so?
Yes, sir, I did. He kept asking to see his lawyer first. I told him that he did not have the right to see his attorney before taking the test, and that by insisting on this would be the same as a refusal. He persisted and didn't take the test.
I think the best charge here is driving while intoxicated as a Class A misdemeanor. The facts in the probable cause affidavit are strong. They clearly show that the driver was intoxicated with drugs or alcohol or both. He was in an impaired condition, so he wasn't operating the vehicle safely, and he had lost control of the vehicle to some extent while driving on the roadway. The way the new statute's written, as a result of him refusing the breath test, he'll lose his license for a year. And that suspension for a year will hold no matter what happens to him in court. So the court penalty will be in addition to that 1-year suspension.
When the officer handling John Doe's case delivers his affidavit and Mr. Doe's license to the prosecutor, the case most likely will be handled differently.
Seems like the probable cause affidavit's in good form. Clearly establishes probable cause that John Doe was operating his vehicle over the legal limit. I think the best charge for us in this case is the per se charge. He tested .11. The limit is .10. All we will have to prove is that he had a blood alcohol of over .10. The evidence that he was driving while impaired is fairly close, and I think it'd just be easier for us if we charge the per se violation. The fact that he consented to the breath test means that he won't automatically lose his license for a year, could suffer some consequences in court instead.
The new statute requires that a judicial officer determine that there was probable cause to believe that the person had violated Indiana Code 911-2. Charges for that violation must be pending against the person for the remainder of the proceedings. After probable cause has been determined by a judicial officer, the prosecuting attorney is directed to deliver the license and affidavit of probable cause to the clerk of the circuit court if charges for violation of Indiana Code 911-2 are pending. The clerk is then directed to forward the documents to the Bureau of Motor Vehicles. If the affidavit of probable cause states that the person refused to submit to a chemical test, the Bureau shall suspend the driving privileges for 1 year. If the affidavit states that the chemical test resulted in prima facie evidence that the person was intoxicated, the Bureau shall suspend the driving privileges for 180 days or until the Bureau is notified by a court that the charge has been disposed of. In either event, the notice to the person advises them that they are entitled to a prompt judicial hearing to review the administrative suspension. The burden is on the suspended person to file a petition for judicial review. Now, this is a pretrial administrative suspension of driving privileges based on the fact that probable cause had been judicially determined and the motorist either refused the test or took the test and failed. The proof required to convict a person of driving while intoxicated remains the same under laws passed by the 1983 General Assembly. An addition is that refusing to take a sobriety test is now admissible in court. The state must still show the driver was under the influence of alcohol, drugs, or a combination, and because of that was impaired mentally or physically to the point where he was a danger to other people on the road. In virtually all DWI cases, it is the arresting officer who must establish impairment from his observations. Field notes can be used to refresh recollections about the defendant's actions at the time of arrest. A test result of 0.10% or above is enough evidence to get the DWI case past a directed verdict or involuntary dismissal, but it's usually not enough to convince the jury that the defendant was impaired. The arresting officer must still do that. In per se cases, however, the offense is simply operating with 0.10% blood alcohol content or above. The test results establish the per se violation by themselves. The arresting officer must, of course, still testify that the defendant was operating the vehicle, but impairment is not an issue in the per se charge. The 0.11% cases that sometimes cause difficulty under the DWI statute should not pose much of a problem under the per se law. The per se statute prohibits operating at 0.10% or above, and it's not hard to prove that 0.11% is above 0.10%. The trial of a person charged with a second or subsequent violation of the DWI or the per se law must be bifurcated. The state must first allege and prove the present case and obtain a conviction. Then the jury is reconvened, or the judge returns in a bench trial to hear the allegation of a prior conviction for the DWI or the per se law. If the prior conviction is established by proof beyond reasonable doubt, the present charge is escalated to a Class D felony. Prior convictions under the old DWI law, the new DWI law, or the per se law are all counted as prior convictions if they occurred within 5 years from the present arrest. Under the changes in state law, a license suspension for failing the chemical test is 180 days or until the criminal case is decided. A driver who takes the test is entitled to credit for the time his license was suspended by the Bureau of Motor Vehicles before he came to trial. That's offset by a court-ordered suspension after a conviction. An example of that is if a driver took a chemical test, failed, and was suspended for 6 months by the Bureau of Motor Vehicles. He then went to court and was given a 12-month suspension by the courts for driving under the influence. In this case, the driver would be credited with 6 months of suspension, the BMV suspension, and would be suspended only for an additional 6 months after the court ruling. If the driver is a first offender, they are eligible for a probationary or restricted license after a minimum 30-day suspension. So there is a big incentive for first-time offenders who took the test to plead guilty quickly rather than delay the day of reckoning. Since a probationary license is only available through the court after sentencing, the first offender's best hope for getting to drive sooner is through a guilty plea. If he delays the case, he remains suspended by the Bureau of Motor Vehicles. However, even if the defendant pleads guilty quickly and receives a restricted license, it won't be effective until he's been suspended for 30 days. All offenders must walk for 30 days at a minimum. Credit for the Bureau of Motor Vehicles suspension is not available for defendants who refuse the chemical test. In refusal cases, the court suspension after conviction is in addition to that suspension by the Bureau of Motor Vehicles. If the court grants a probationary or restricted license, the special license won't become effective in refusal cases until after the suspension set up by the Bureau of Motor Vehicles is completed. Obviously, the intent of the law is to cut down the number of refusals to take a chemical test by drivers who are suspected of driving under the influence. The driver agreed to take a test when they got their Indiana driver's license. The law is saying if you keep your promise and you take the test when asked to by an officer, that even if you fail, you will not be treated as harshly as if you refuse to take the test at all. If you refuse the test and you're found guilty, you will have a mandatory 1-year suspension of your license. If you take the test and fail, the law provides a credit for the time your license was suspended before any criminal court action on your case. The restricted or probationary license provisions have been broadened to include driving to and from a court-ordered treatment program and to and from work. The court may also authorize driving for a specific purpose under exceptional circumstances. The jail terms and fine for DWI are the same under the new statute. Class A misdemeanors are punishable by up to 1 year in jail and a fine of up to $5,000. The new per se law is a Class C misdemeanor, punishable by up to 60 days in jail and a fine of up to $500. A second and subsequent conviction for drunk driving or the per se law is a Class D felony. The mandatory 5 days in jail minimum is retained for second or subsequent convictions. Repeat offenders are not entitled to a restricted license. The pretrial Bureau of Motor Vehicle suspension provisions are the same for repeat offenders. The new law contains an amendment to the driving while suspended statute. The amendment requires a mandatory 60-day jail term for anyone convicted of driving with a suspended license where the suspension resulted from a DWI or per se conviction. Now, keep in mind that this mandatory 60-day sentence applies only to suspensions resulting from convictions. The Bureau of Motor Vehicle pre-trial suspensions themselves do not invoke the mandatory 60 days. Of course, a person caught driving during a Bureau of Motor Vehicle suspension may still be arrested and convicted while suspended, but the 60-day minimum penalty is not mandatory. In a companion bill, the legislature gave the Indiana Department of Motor Vehicles the authority and the duty to administer the habitual traffic offender statute. Under Senate Bill 169, which was effective September 1st of 1983, the Bureau of Motor Vehicles is directed to suspend the license of anyone meeting the habitual traffic offender law. Under the old law, the Bureau of Motor Vehicles was directed to certify to the local prosecutor that a person was eligible for revocation under the habitual traffic offender statute. Traditionally, however, the HTO license cases were not given much priority by prosecutors concerned with felony and misdemeanor cases. The new law takes care of this by directing the BMV to simply suspend the license instead of certifying the case to the prosecutor. Now, more than 16,000 drivers meet the HTO criteria as of September 1st, 1983. Nearly 14,000 have reached this point due to repeat drunk driving convictions. The crime of driving after an HTO suspension is a Class D felony, and it's punishable by up to 4 years in prison and a $10,000 fine. The offender's license is suspended for life upon conviction.